Go on. Okay, we're gonna go ahead and take care of the municipal.
No problem, Judge.
Yeah.
I have Snell. Let them go first. Snell.
Okay.
I have Snell, but they, Mr. Atria,
Now-
Mr. Lingerie, friends of mine, they definitely go.
You can have these for K pieces.
Thank you
Yours.
very much, I really
Yes,
appreciate that.
I'm in
Very
no
nice.
particular rush, okay? But hurry up.
This is Lauderdale Lakes. Where's Jerry Hamilton?
Don't do Lauderdale Lakes.
Jerry Hamilton, followed by Suleiman Smith and Caroline Clozier. Jerry Hamilton. Where's Jerry?
Maybe right at Maine. Turn on my.
Mr. Hamilton is on his way, Judge.
That's not Hamilton.
Could you step back a little bit, Mr. Smith? He called Hamilton first. All right, there you go.
Sir, in the city of Lauderdale Lakes, you were allegedly drinking beer, Colt 45, out in public. You want to work it out right now and plead no contest?
Yes, sir.
Do you need me to give you an attorney, or can you go without an
So I
attorney?
thought I did something.
What do you think?
Anybody?
Do you want an attorney, or can you go without one?
I can go
This is
without.
resisting
How do you plead,
violence,
sir?
and this guy's got two of
I
them.
plead
Open container and trespass.
no contest.
I'll withhold adjudication. Good luck. What
And
about
younger-
Solomon
And yeah,
All right, Mr. Hamilton, go outside and have
Suleiman
a
Smith?
You're done, Mr. Hamilton. Good
How you doing?
luck.
How you doing?
Judge, I had a
Your
chance
Honor,
to speak
early.
to the city prosecutor.
Okay,
How you doing, Your Honor?
good, sir. Are you working?
Yeah, I have a job at Lake Pool, sir.
You have money in the bank?
No, sir.
Okay, so I'm gonna appoint FJM. And
Wait, Lawrence.
let me ask you, we've got an attorney over here for you. Did you have a chance to speak with,
I did, Your Honor. The city's been very generous.
I talked to him.
Hold on,
What did they
sir.
say?
Hold on, sir. The city is offering an adjudication credit for time served.
what do you wanna do, sir?
That's
The
right.
lawyer over here worked out a deal where you just get adjudicated, get time served, that's the end of it, and you're out of here. Is that what you wanna do?
Yes, sir. I take that, sir. Yes, sir.
And I think there are two cases, Your Honor.
Two separate cases. Sir, if you plead no contest, I'll withhold adjudication on the controlled substance so you don't lose your license for 2 years, all right?
Thank you, Judge.
Now,
Thank you.
you want to plead no contest to both these?
No contest,
You
sir.
understand, we're not going to have a trial, we're not going to appoint an attorney, right? I mean, no, we already did appoint an attorney. You understand? The case is over with, I talked to your attorney, the attorney had worked this deal out for you. Is that what you want to do?
Yes, sir.
All right. I'll accept your plea of no contest, count one withheld. Adjudication, count two adjudication, all right?
Thank you, sir.
Good luck.
Thank you, sir. Middle turn around.
There you go, Mike. Pick up.
What about Caroline Clozier?
Thank you, sir. North Broward.
Ms. Clozier, you're charged with a resisting arrest. Ma'am, are you working at this time?
No, sir.
Do you have money in the bank?
No, sir.
Okay, what's
Judge, I had an opportunity with this lady's case as well. City has offered, if she would like to resolve it, an adjudication time served.
okay, ma'am, I'm gonna appoint an
Yes, ma'am.
attorney over here to represent you. He's already worked out some kind of deal with you. Do you wanna work it out right now?
Yes, sir.
You plead no contest, I'll adjudicate you, give you time served, and you're out of jail. Is that what you'd like to do?
Yes, sir.
You understand, we're not gonna have a trial, we're not gonna appoint an attorney. No, we already did appoint, sorry about
You
that.
did, Judge.
We appointed an attorney. You understand the case will be over with today, ma'am?
Yes, sir.
How do you plead?
I plead no contest.
I'll withhold adjudication. Thank you, ma'am.
All right, thank you, sir.
Thank you, Your Honor.
George, our last one is Leonard Younger. He's from yesterday.
I don't know that I have that.
We did not yesterday, but you should have it today.
I don't have Leonard Younger.
Okay, that's all I have then.
Now, I do have two other ones. I have, there,
Go ahead, Your Honor.
where's Shade? Is he around? Shade?
Judge, I don't think so.
No?
I'm getting all that.
Hold on.
Doesn't mean he's not here, I haven't seen him.
Okay.
Tell Miss Diaz is here, I'll come right over.
You guys.
Sorry.
Shameless.
Where's Alonzo Smith?
You're kidding, Alonzo Smith.
Alonzo Smith, where are you, sir? Right there.
President's main, Judge. Come on, Mr. Smith, step
I'll
up.
represent the state for all on this case, is okay?
Okay. Mr. Smith, you've got count 3, open alcohol container, count 4, open alcohol container. Would you like to resolve your cases today? You can plead no contest. They're wrapped up today.
Yeah.
Is that what you want to do?
Yes.
Do you need an attorney to help you go over this stuff, or can you go without it?
No. No, I don't.
Okay, how do you plead?
No contest.
I'll withhold adjudication on both cases, all right? On 3 and 4, thank you. How about Jose Nunez?
Long time to have speech, sir.
Nunez, sir, count 2 is a...
Spanish?
Spanish.
Spanish.
Okay, hold on.
Take medication?
No hablo español. I mean, no hablo inglés.
No.
Solamente español.
Okay. Now, does anybody know what count 1 and 2 is on Nunez?
He was here yesterday, I remember that.
What? No, I know, but do you know what count 1 and 2 are?
Count 1 is case from yesterday, Terry open beverage and public unit adult public education.
Right.
And counts 2 and 3 are petty theft and carrying beverage.
1 and 2 are open containers, right?
Count 1 that you withheld education is the open container. Count 2 is petty theft and count 3 is open.
What did I do with on petty theft? Is it resolved?
No, that one is actually why he's here today. He's here and
Oh, you're right, okay, I got it, I understand. Okay. Okay, no. Take care. Siete say, por favor. Siete say, por favor.
Yeah, here's the problem. He advised he believed suspect in terms of the body.
What can I do for you, Mr. Bronte?
Judge, there was a case that was reset from yesterday. The family came in and hired me yesterday afternoon. It's Snell. It's an armed burglary, ag assault, firearm.
Okay.
Two counts of ag assault, firearm, 2 counts of child neglect, and I think there's a shooting into an occupied dwelling count. I don't have the case number, but the state is aware of it. He was actually kind enough to tell me that it wasn't this morning, it's this afternoon, so here I am. Nice to see you again.
See you too.
It's been less than 24 hours, Judge.
Okay, Snell, please.
He's up there.
There he is, okay. Moment.
Can Mr. Snell hear me? Mr. Snell, can you hear me?
Yeah, I need to talk a little louder though.
Okay, this is your lawyer. This is Louis Parenti, okay? Your family came in yesterday afternoon and hired me to represent you, okay? We're going to try and see what we can do about getting the bond today. That's maybe a little bit difficult, but either way, I just got the case and I'm going to come see you this weekend, okay? If we don't get a bond today. So just be chill and don't talk to anybody about the facts of your case. I'm going to invoke your right to remain silent here on the record, okay?
All right. Yeah.
Thank you.
You're welcome.
Mr. Snell, you've been charged with armed burglary on count 1, count 2, 3, and 4, aggravated assault with a deadly weapon being a firearm. Count 5, throwing a missile into a dwelling. Count 6 and 7 are child abuse without great bodily harm. State, are you seeking a foreclosed bond and release conditions?
Yes, Judge.
Okay, go ahead and tell us why your position this would reach the level of proof evident presumption.
Your Honor, relying upon the arrest warrant affidavit prepared by Detectives Stephanie Jacoby of the Broward Sheriff's Office, I believe there is proof evident based on this evidence. statements taken from the alleged victim and witnesses that Mr. Snell, without any lawful permission, using a ladder, entered the second floor apartment of the victims through a sliding glass door. At that point, he then pointed a small firearm at both victims/witnesses, evidence indicating he was armed at the time, Your Honor. He then proceeded to the third victim's room, pointed a firearm at her, and actually fired a firearm. Physical evidence corroborating that, Your Honor, is that there was a bullet hole in the headboard of the bed in the room. The bullet went through the wall of that into the next residence and was lodged in the headboard in the room in the adjacent residence, Your Honor. Additionally, the witnesses that were outside the room gave a statement that they heard the victim in the room screaming, "Don't do it, David," then saying that a gunshot went off, and then everything got quiet. Additionally, Your Honor, another witness, Jeremy Jean, told law enforcement he had a conversation with Mr. Snell, that he was advising him not to go to the apartment. His reasoning for not to go there is he was saying that she's could be at the house with her new boyfriend, and he believed that Mr. Snell would not be able to control himself. Additionally, Tiara Ruffin, who is the mother of Mr. Snell's children, said that she and his ex-girlfriend, that she got a call from him, that she could hear Chantrice, the victim that who was in the room when he fired the gun, crying in the background, which would seem to again corroborate the evidence that's been provided to Detective Jacoby, Your Honor.
Right. Mr. Bronte, do you have a response?
Yes, I do. First, Judge, I think it should be noted that the reason that my client went over there was because he was given a call by the person who said he told him not to go over there, informing Mr. Snell that his children were left alone in that apartment, the girlfriend or ex-girlfriend who was supposed to be there wasn't there, that these young kids were left in the apartment unattended, the people in the apartment were all getting high, and that's why he went over there. That's, as far as whether or not he was invited in or not, Judge, I don't know, but certainly to me, he's acting in defense of his children who were in crisis based upon the phone call. The people who had the most to lose are the ones who all want to testify against Mr. Snell about what he did. Because the ex-girlfriend who was supposed to be there with her kids and wasn't, she's the one who should be charged with child abuse or child negligent care of a child. Not Mr. Snell. He's trying to protect his children. So that lady definitely has a motive to lie. She should have been there. She wasn't. Her kids were unattended. Those people that were in that apartment barely know those children, have no connection to those children. So she has a motive to lie. The two people that were in the apartment when he showed up, or three people that testify against him, they also have motives to lie, Judge, because they were getting high. And they had these children in the apartment. So, to me, to say that it's proof evident, and I have no idea what the prior records are of the alleged victim, which I'm pretty sure she has a record, and I'll bet if we run the two witnesses, I'd like to know what their records are, because certainly that would go to the credibility of their statements. So therefore, we don't know that. I can speak to my client doesn't have a record because he has a carry permit for that gun. So I don't know how we can get the proof evident presumption grade.
The problem is Mr. Peroni's argument. That's all it is. It's argument. There's not one piece of evidence before Your Honor to support his argument. There's no evidence that anyone in that home was using drugs. What I find ironic is his explanation for why he was going to that house, because he was concerned for the welfare of his children, seems to contradict the fact that he fired a gun in a room that there were two small children in, putting those children in danger. Firing a gun that went into another residence. Who knew if there were children in that other residence, Your Honor? So I find, based on the evidence before Your Honor, that which the court can consider, that there's a contradiction in even the argument, the explanation that's being proffered for why he did what he did.
Okay, Mr. Bronte, I'll give
Judge,
you the last quick brief word.
Okay. Judge, I think that at this point the state has an obligation now to come forth with the criminal records of the witnesses that they're relying on their statements. Because certainly if they're convicted felons, Judge, that goes to their credibility. And
You know, that would be a fishing expedition that really is not the basis of whether or not there is proof evident presumption. Great. I do respect the fact that you're a zealous advocate for your client. However, today I'm not going to go down that road. Obviously, you can cross-examine people at subsequent hearings regarding that. Today, the court will find proof evident presumption great as to the armed burglary, count 1, and regarding the count 2 through count 7, the state needs to set a bond. You said there's no criminal record.
There is no, Your Honor.
Okay. Now,
Judge, he's employed. He has substantial ties to the community. He's an employee of Walmart.
okay. Does he have money in the bank that you know about?
Not that I'm aware of. His family is pitching in to, fund the defense of the case.
Okay. I'm going to set his bond on count 2, 3, 4 at $5,000 per count, and then the $5,000 on the miscellaneous dwelling, and the 6 and 7 will be $1,000. All right.
Okay, Judge, because it's the weekend, is there any way that I can make a request to the clerk that they expedite the file so we can get a case number on it?
Case number. We ask that a case number be issued on this as soon as possible.
Thank you, Madam Clerk.
Defendant's going to be held without bond. The court finds there is proof evident presumption grade based on the affidavit. Now, the court will order that the defendant have no contact. Will you please tell us the name of the alleged victim?
It is
Shannon York is one. Chantrice Jean is the other. No contact with them directly and
And
indirectly.
lastly, Your Honor, Wanya York.
Wanya York, no contact with them.
And just an abundance of caution, let me just ask Mr. Rodney.
I'll let Mr. Snell.
Yeah.
What are your children's names that were over at that house?
Trinity Snell and Daviana Snell.
Okay, thank you.
Your Honor, we were just asking an abundance of caution. There's two children mentioned, counts 6 and 7, both with the initials JJ. We were just asking an abundance
No
of caution.
contact with JJ directly or indirectly. Thank you.
Mr. Snell, I'm going to see you tomorrow. I'm going to see
Okay.
you tomorrow at the jail.
Mr. Parante,
Okay.
I think you have some of the family
Okay.
right there behind
All right.
you. Mr. Parante, can I ask you to come up here real quick?
Sure. Number, hopefully. Thank you.
Thank you. Thank you. Which case are you here on in the very back?
I think they're with.
Oh, okay. John McLeod.
Hey, jail.
McLeod, you're charged with battery, criminal mischief, 2 counts of resisting, 1 with violence, 1 without. And
I'm sorry, I was just going to say on count 5, as I reviewed this, it should. I think that it was the officer's intent to do corruption by threat, not 3A, where there has to be actual harm.
even if it's corruption.
And I would argue
threat,
against probable cause on count 5.
I think it's kind of such a veiled threat. It's kind of a weak veiled threat.
I understand, Your Honor.
I'm going to find no PC on count 5.
Thank you, Judge.
So, count 5. Now, let's talk about. Hey there, you need something? Hold on one moment. All right, John McLeod, court finds probable cause to 1 through 4. State of their priors.
One moment, Judge. Yes, Judge. His priors include possession of marijuana 2011, disorderly conduct 2010, possession of cocaine 07, possession of marijuana with intent to sell or deliver at or near a school or park in 04, 18 and a half months state prison, possession of marijuana 04, resisting without violence, leaving the scene 03, robbery with a firearm or deadly weapon 97, 4 years state prison. You here tomorrow?
All right, Mr. Miller, anything you'd like to add?
Judge, I would just ask the court to reconsider PC on count 3. The way it's described, they were trying to pick him up with the handcuffs on. He could very well have stumbled or twisted as he was trying to get up. It doesn't necessarily, I mean, he didn't connect with anybody, didn't hit anybody. He just twisted as he was getting pulled up with handcuffs on. If you've ever seen that happen, you know that that's a painful situation. He could have just been responding to the pain. I would argue there's no PC for count 3. Judge, he's a 33-year resident in South Florida, 3 years at his current address. He works odd jobs to take care of 4 children, aged 10, 5, 3, and 9 months. He has strong family ties, no money in the bank or real estate, no one to help bond him out.
Okay. All right, so that's where we are. Let me just look at the.
And Your Honor, I would just argue based on the
contact with the alleged victim.
Judge, I tried several times, she keeps ringing busy.
Allegedly against his sister, kicked her door, screaming at his sister, allegedly struck her, put both hands on her chest, shoved her, threw her into a closet just inside the apartment, and allegedly got rough with the police when they got there. Sir, I do know you have a prior robbery with a firearm, some drug charges. Court's gonna set your bond on the domestic violence at $5,000. Count 2, the criminal mischief, 100. Resisting arrest without violence, 1,000. Count 4, I'm gonna release you ROR, and your total bond's gonna be 6,100. Count 5 is ROR. All right? Thank you.
Thank you, Judge. All right, down the middle, out the door.
Hold on 1 moment. I don't want you to have any contact directly or indirectly with Sue Daniels. Don't call her, text her, email her, stay 500 feet from her. Where she lives and works, anywhere in between, no guns or weapons may be in your possession while you're on bond. Thank you.
Thank you, Judge. Maury?
Okay, may I see Maureen Simon, Caitlin Thompson, and Zoya Robinson.
Judge, we have a bit of a problem with Miss Simon. This is count 5. She was released to BARC IRT. Apparently there's a bed available for her, and as she was getting ready to get transported, this popped up, and she's saying that this is a not me case, that it's her sister who in fact used her name. Is that right?
Yes, that's correct.
And this is a 2011 case. Judge, I'd hate to see her miss her bed at BARC where she can get some real help. Any chance we can get a ROR on this? Put her on, she can be, locked down at the BARC. She's not going anywhere, and we can sort this out later on.
What is count 1, 2, 3, and 4? Right. Do you have the facts of the case on this? Do you have the probable cause affidavit in there?
The 2011, I don't think anyone's going to be able to get you the facts. Of the case. But Judge, I have no objection if the court's agreed.
Okay, I'm going to release her on her own recognizance, all right?
Thank you, Judge. Appreciate that.
Thank you, Your Honor.
Okay, so just go to the not me and explain to them what's going on. They'll compare fingerprints and all that.
Okay, will they send me something in the mail?
Yeah, you'll get a date in the mail.
You see Leonard Younger? Leonard Younger. Is he there? reset him a couple times. I'm gonna reset him for Saturday.
Younger's north.
Is he?
Younger's north, Your Honor. Yeah.
Got it.
Come on.
Younger? Do you still live on 11th? Do you live on 11th Avenue, number 3 in Fort Lauderdale?
Yes.
Okay, I'm gonna release you on your own recognizance. You'll have to come back to court, all right?
Sure enough.
Okay.
Thank you. Okay, you're here on Callaway? Anybody see Callaway on the docket?
Towards the back.
See?
Sorry, it's not big.
Can I see Mr. Callaway?
Am I wrong? It wouldn't be the first time.
Says your name, say no.
I don't see Callaway.
Let me, just one moment, Judge. I could be wrong.
What, excuse me? I don't know yet. Just give me a moment.
They were going to make arguments.
Right there, that's good. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Now, put down your hand. Let me ask you, ma'am, tell us your name.
Carolyn Washington.
Okay, and you have a problem with a man named Callaway, correct?
Yes.
What's his first name?
Joshua.
And he dates your daughter, right?
Correct.
How long has he been dating your daughter?
A little over a year, maybe.
Now, you say he came yesterday and scratched you?
He punched me in my face.
Do you know why he did that? I mean...
It started last week, actually, when I saw him beating on my daughter in the street. I asked him what he was doing. Not only did I see it, there was a lady that lives 4 doors away from me who actually came to my house and asked me if the young lady was okay. He turned around to me, he told my daughter to F you, and the same thing to me, F you bitch, pointed in my face. Then yesterday, while I was at home, I went in the kitchen to get something to eat, and I saw a fork that I did not recognize in my cutlery drawer. And I asked my daughter, whose was the fork? She says it belonged to Josh. I told her I didn't want anything that belonged to him in my house, so I threw it in the garbage. At that point now, she calls Josh and tells Josh I just threw his fork in the garbage. Next thing I know, boom, 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 on my front door, it was Josh. So I says to Josh, please step away from my property. He asked me if he could have his fork back. I gave him his fork. He pointed the fork inches from my face, and literally an inch. He had the fork pointed to my face. I felt threatened now, so I pushed him. I'm not sure if I slapped him because of what was going on.
This. What does Josh do for work, do you know?
I have no idea.
Is he in school?
I don't think so. And neither's my daughter. She works as a part-time hairdresser.
How old is your daughter?
20.
Okay. did Josh come over to your house after you had told him not to come back over?
Well, I told my daughter to tell him I don't want him at my house. I physically didn't tell him myself. I just told my daughter because she's been very disrespectful to me these past few months. So I've stopped her friends from coming over to my house, including him.
And Your Honor, just so you know, Ms. Diaz is going to be here tomorrow, and I'm going to ask her to speak to her. And we can also, so you don't have to come back tomorrow morning, we can relay everything to Judge Lopane that we believe is appropriate for him to know.
Okay.
I understand, and that's going to be, how Your Honor deals with that's up to the court. I mean, the court is, if the court believes that has concerns, especially regarding a no contact order, it was not unlawful for the court to order that he be held for his first appearance tomorrow. Because we don't have a report, we don't have.
I have the paperwork. I'm going to do that. I'm going to order that he be held till his first appearance, not to be able to have a convenience bond. Okay?
And,
okay.
Thank you.
Well, Ms. Diaz here will speak with you and get some information from you that we can present tomorrow.
No problem.
You want to come in tomorrow?
Thank you.
State, can you write an order?
Yeah, sure.
Thank you.
Thank you.
Thank you. All right, where's Caitlin Thompson?
She's present at the main judge. She's indicated Justin Weisberg is her attorney.
Justin Weisberg. All right. Do we know Justin Weisberg's number?
I can get that for you in just a second. Yes.
Who's? Ma'am, your bond was posted. You'll be out of jail shortly. Thank you, ma'am.
Good job. You'll be out shortly. Sit down. Thank you. Zoya?
Zoya Robinson.
Present at the main.
Hello, Ms. Robinson. Ma'am, you've been charged with DUI property damage, and count 4 and 5 probation violations, ma'am. Breath reading in this case, a .153135. Ma'am, the court's going to find probable cause to count 1, $500, 2, $1,000. You'll be held without bond on count 4 and 5. Thank you.
Sorry about that, sweetie.
Missy Alexander Gomez, Robert Lasciavo, and Gary German.
Judge, this.
All right, Gomez charged with battery, sir. Court finds probable cause. Do we have any priors on Mr. Alexander Gomez? He's been known
Judge,
as...
while he's looking that up, I'd like to invoke the right to remain silent for John McLeod and for Ms. Robinson and for Mr. Gomez.
Let me just say that Mr. Alexander Gomez has been known as Derek Gutierrez, Michael Chisholm in the past.
And we have an argument for Mr. Gomez.
Do we know if we need any?
Spanish.
Okay. Did Mr. Miller say he has argument, or?
Well,
I did.
On probable cause?
On probable cause
go
for
ahead,
Mr.
sir.
Gomez, yes.
Sorry.
Yes, Judge. So, the incident is alleged to have occurred at 2700. That's Mr. Gomez's address, not the neighbor's address who is alleged to be the victim in this case. I would argue that the alleged victim, who had no visible injuries, was transported because he's claiming he's got his ribs hurt. My client, who needs a photo order, by the way, has visible injuries. So this is clearly a mutual combat situation. Two people are fighting. The officer says Mr. Gomez is the aggressor, but does not give any supporting facts to advise the court how he concluded that Mr. Gomez was the aggressor. And so I would argue, Your Honor, that in a case of mutual combat, where there's no facts before the court, to determine how it was determined that he was the initial aggressor, that there is no probable cause to hold him for this battery, and I would ask the court to release him on his own recognizance.
Thank you. Court will find probable cause today. Go ahead, State.
Yes, Judge. Priors include 2 counts of battery, 1 count of cruelty to animals, 2013. In 2013, 3 more trespasses, a disorderly conduct, criminal mischief, 2013. Wait, he just left.
Tell him to come on back.
He's coming back.
Yeah, Mr. Gomez, you got to stay there. Go ahead.
2012, possession of marijuana. 2011, grand theft. 2011, theft. 2009, disorderly conduct. 09, leaving the scene of a crash. Possession of marijuana. 08. Multiple priors for possession, anywhere from possession of marijuana with intent, felony possession of marijuana, misdemeanor possession of marijuana, leaving the scene of an accident in 03. Your Honor, I would say about 10 priors involving marijuana.
Okay. Got it. Okay. Anything you want to say on behalf of this defendant's ability to post bond?
Judge, he's unemployed at the moment, no money in the bank. He does have family down here, 20 years in South Florida, and he's hoping his mother will bond him out. And again, just renew my argument, Judge, that the probable cause affidavit is conclusory.
Thank you. Bond's 1,000, sir, based on the level of violence, criminal record, no contact.
Good luck.
Directly or indirectly with Francisco Diaz. Robert Lociava.
President, the main declined CD.
Sir, DUI, second offense. Yep, in just a moment.
Your Honor, the first offense was thrown out of court. I was found innocent on that one.
You guys on the back row, move up front. Y'all move up front.
Sir, your bond has been posted. Thank you.
Good luck.
Okay. Thank you, Your Honor.
Gary, right? Gary German, yes. Okay.
Outside,
Gary German, your bond has been posted.
Yes, sir.
Thank you.
Thank you. Good luck.
Okay, ready to go?
We invoke Mr. German's right to remain silent.
Jose Nunez.
Jose Núñez.
Nunez is president of the Maine.
Mr. Ma'am, do you swear or affirm to translate from English to Spanish, Spanish to English truthfully to the best of your ability?
Yes, I do.
Sir, on count 2,
El cargo número 2, señor.
you are charged with
La acusación es
charged with a theft.
robo, hurto.
Count 3,
Cargo número 3,
you're charged with a open container of alcohol.
envase abierto de bebida alcohólica.
Count 2, your bond's $500.
$500 la
Count
fianza
3, you'll
número
be
2.
released on your own recognizance.
Cargo número 3, se le deja en libertad bajo su propia responsabilidad.
Thank you.
Gracias.
Thank you, Judge. Adios. We have one more.
You want to have a Spanish speaker over there?
I do. Señor, por favor. His name is Milton O'Neill Rodriguez on page 7 of your docket.
Sir, you are charged with resisting arrest without violence,
Resistir la violencia, resistir el arresto sin violencia es la acusación que tiene.
driving on a suspended license,
Conducir con licencia suspendida
and displaying a revoked license.
y mostrar una licencia que está revocada.
Sir, how long have you lived in South Florida?
Señor, ¿hace cuánto tiempo que vive usted en el sur de la Florida?
¿Cuánto tiempo vivo en el sur de la Florida?
How long have I been living in South Florida?
Yes.
Sí, señor.
Casi 4 años, voy a tener 4 años.
Almost 4 years, very soon 4 years.
Do you still live on West 24th Court in Hialeah?
¿Usted todavía vive en el West 24 Court de Hialeah?
Yes, sí.
I'm going to release you on your own recognizance.
Lo voy a
today.
dejar en libertad bajo su propia responsabilidad hoy día.
Thank you.
Gracias.
Thank you.
And we invoke Mr. O'Neill's right to remain silent.
I see David Duncan.
North Broward.
Mr. Mr. Duncan,
Yes, sir.
you're charged with
Obstructing traffic.
trespassing. So would you like to resolve your case today, Mr. Duncan? Thank you.
Yes, sir.
How do you plead to trespassing?
No contest.
You understand we're not going to have a trial? The case will be over with today?
Yes, sir.
Okay, sir. I'm going to withhold adjudication, so I'm going to remind you you're not allowed to panhandle and around traffic. All right?
Actually, I was just trying to cross the road in my wheelchair.
All right. Yes, sir. Leonard Berry.
Go.
Mr. Berry, you have an unlawful sticker case. Would you like to
Judge,
resolve it now?
I really would.
How do you plead to this charge, sir?
No contest?
You understand we're not going to have a trial. It's over with now?
I do.
I'll withhold adjudication, sir. Thank you.
Thank you.
Mr.
Thank you.
Jason
Thank
O'Brien.
you. Good luck, Mr. Barry. Thank you. Yes, sir. Mr. O'Brien has declined the services of the public defender, Judge.
Sir, DUI? Sir, you're
Yes,
charged
sir.
with DUI?
Yes, I was charged with it, but I wasn't even driving a vehicle.
I
I
understand.
pulled in.
I understand.
Yeah, I wasn't charged.
How do I know? Yeah. When it's a low-level misdemeanor?
Yeah, you don't need to say anything, sir.
Okay, I
But
apologize.
you don't need to say anything, but you don't need to respond, but I'm just going to clarify an issue. You just said you weren't driving. You don't need to say anything else, but I'm going to tell you what it says in the report. It says that a report of a reckless driver in Plantation, and it looks like sometime around midnight. It says that when the police officer got there, the defendant was sitting on the curb. There was a police officer named Claire. Officer Claire advised that he had witnessed the subject behind the wheel and that he was the sole occupant of that vehicle.
Yes, sir.
So I'm just letting you know that the police, you don't need to say anything. They have a different
Yes, sir.
version. Now,
Okay.
your bond has been posted. You'll be out of jail shortly. You're not allowed to consume any alcoholic beverages while you're out. And also, you only have 10 days to go get a temporary driving permit at the DMV. It's at Oakland and 441, southeast corner. All right?
Okay, sir.
Thank you. Jeremy Shelton.
Well, still clear it upstairs anyway.
Shelton is president of Maine. We revoke his right to remain silent.
So you're charged
Yes,
with
Your Honor.
license suspended, Mr. Shelton. Just keep it moving.
Yes, Your Honor.
He was arrested on Saturday for DV battery and DWS.
Okay. All right, sir. What do you do for work right now, sir?
I work at a call center, DirecTV. It's called Converges.
I'm gonna let you bond. Your bond's $100. Thank you.
Good luck.
How about
Thank you.
Devontae Fowler, James Frazier, and Adrian Morris? Line up, please.
Mr. Fowler is at the North Broward, I believe.
Fowler's at North Broward. Fowler, count one, cannabis, 103, no bond, probation violation.
Judge, I would invoke his right to remain silent on the probation violation and the new possession canvas.
Sir, okay, thank you. James Frazier.
Frazier is president of Maine. We invoke his right to remain silent and request a
Sir,
protective order.
cocaine, count one, drug paraphernalia, count two. Do you have any priors on this gentleman?
Trees, do you have? I have a 2005 burglary of an occupied dwelling and grand theft with a VOP where he was sentenced to 90 months in state prison. I'm imagining there's more than that. Patrice, is there prison sentences on those also?
Sir, are you currently employed?
Do you have a job?
I'll do piecework, sir.
Odd
Do you have
job,
any money in
Judge.
the bank?
He's, no money in the bank.
No money
He's
in
a
the bank.
lifetime resident, and he does have family that lives down here.
So I'm going to let you go to pretrial release. You have to be there on Monday between 8 and noon time, right across the street from where the jail is. They'll give you a map right there, all right?
Yes, sir.
Thank you.
Okay, this is where you are. That's where
Adrian
you go
Morris.
before noon on Monday, okay?
Decline PD.
Decline PD, Judge.
Okay, so
Yep, you're good to go. Good luck.
Adrian Morris. Possession of a controlled substance without a prescription. Carrying electronic weapon or device.
Ryan?
Cocaine. What finds probable cause? State, do we have any priors on this gentleman?
One moment. He does not have any priors, Judge.
No criminal record. Sir, do you still live on Kathy Court in Margate?
Yes, sir.
Are you working at this time?
Yes, sir.
Where do you work?
I do construction for my dad, sir.
Okay. Did you graduate from high school?
No, sir.
How far did you get?
10th grade.
Did you get a GED?
No, sir.
No? Okay. Here's what I'm going to do. I'm going to release you on your own recognizance to pretrial release today. You're going to get drug tested every week. Within 10 days, you need to sign up for a high school classes to graduate or a GED, one of the two. 10 days to do that. Do you understand?
Yeah.
If you don't do one or the other, I'll have you rearrested, put back in custody. Do you understand that?
Yes, sir. I'm gonna go get a GED, sir.
What?
I'm gonna go try to get a GED, sir.
You have 10 days to sign up and start classes. Is that clear?
Okay, sir.
And if you don't do that, and if once you start, you drop out, you stop going to classes, you flunk classes, you don't show up or you run late,
So how would I do?
I'll have
How would
you
I do that?
rearrested and put back in jail, all right?
How would I do that between my jobs, sir?
You're gonna have to work it out. You go night classes, go on the weekend, all right?
All right, sir.
All right? Thank you.
Yes, sir.
Release ROR, you have to be at pretrial release on Monday. Hold on, let me get. I'll be right back. Hold on.
Evidence. It's all her.
Ryan Campbell.
President, the main judge, we have an argument.
Okay, sir, you're charged with robbery with a weapon. Go ahead, Mr. Miller.
Judge, I'm reading this probable cause affidavit, and it just all appears to be lacking any kind of evidence. It's all testimonial in nature from an ex-girlfriend against her ex-boyfriend.
Right.
There's no injuries that were reported by the police. So if this did happen, as this woman said, there should be an injury observable by police and reported on this probable cause affidavit. There's nothing. And when they arrested him, there is no cell phone. And so, you know, there's no cell phone recovered. There's no injuries where there should be. And you have clearly a woman scorned here giving testimony of an incident that nobody corroborates. Judge, I'm arguing there's no probable cause here, and I would ask that my client released on recognizance.
Well, let me take it from the top. Number one is, one of the major differences between a civil tort and a criminal act is that criminal does not require damage, where a civil act requires a civil tort of battery requires damage. The criminal battery does not require the element of damage. Number two is, frankly, I don't know if she's a scorned woman or not. That's going outside of the four corners of the document. I have no idea if she's scorned. I have no idea about that. So I'm not sure that I can factor that into the analysis of probable cause. But now that being
Judge,
said,
briefly, may I just, Judge, we're not saying that. I'm not saying should be a civil tort. What I'm saying is, if what she described actually happened, then one would expect there to be some physical evidence of the action. So if he pushed her down, punched her in the ribs, something would show, and the police would report that on the probable cause affidavit. None of that is present on the probable cause affidavit.
But without going too far down this road, if she gets punched in the ribs and there's no female police officer around, they may not ask her to pull up her shirt.
EMT was there.
You know, I don't know the whole, but I'm going to find probable cause. I do acknowledge your argument. You brought up some points, and a lot of times these points are good points. They're just good points probably for trial. But go ahead.
He has no priors.
Okay, so he's got no criminal record. He allegedly takes a telephone from his ex-girlfriend. So what do you want to say about this defendant, sir? He's got no
Judge,
criminal
I didn't get a chance to talk to him about his ties to the community. How long have you lived in South Florida?
5 years.
Okay, how long have you lived at your current address?
2 years. This started on be like 3 to 4 years now.
Are you working now?
Yeah.
How long?
Like a year now.
Where are you working?
Jumper demolition.
Do you have any children you take care of?
No.
You have family living here in South Florida?
Yeah.
Okay. Who lives down here?
My mom, my grandparents.
Okay. Any money in the bank?
No, maybe that's like $5.
$5 in the bank? No land or real estate?
No.
Okay. Do you know who's going to help bond you out?
I have to try to get in contact with my mom.
Are you in school or anything like that?
No, I stopped.
Okay.
I'm just thinking. I'm going to finish my
How
GED.
far
There
did
you
you
go,
go at
Judge.
school?
12th grade.
Okay, you graduate?
No.
No? All right. And what type of work do you do?
Demolition, John Pro.
Okay. Well, he's got no criminal record. Sir, let me ask you something. I'll give you a bond today. I believe a reasonable bond. But I want you to know you can't have any contact with this young woman any further after today. Do you understand that?
Yes, sir.
And that is Miss Shannon C. Paul. You cannot contact her in any manner. Is that clear?
Yes, sir.
You have to stay 500 feet from her at all times. You understand that?
Yes, sir.
Now, who's going to help bond you out of jail today?
I have to contact my mom, my parents.
I'm going to set your bond at $3,500 today, all right?
Thank you, Judge.
Thank you. That's
All right. Good luck.
a reasonable bond.
Thank you, Judge.
Claude Murray.
North Broward. Okay, who do we have here?
Mr. Murray.
North Broward.
What's your name? Innocent. And you're going to get hired.
Count one.
You're going to get
resisting a
private.
detention
What's your name?
operator.
Roberto.
Detention. It says operator, but
And your name? Okay. Gregory, you're here on a second look docket. Spell your last name. All right.
Sir,
Okay.
count one
What are
is
you in
a
on?
resisting a
Okay.
a
And what's
mark
your bond?
Count two Count two is a felony theft. Count three resisting arrest with violence.
I'll let the judge know. You'll be the last
Sorry,
one up.
Count four is a misdemeanor assault on a police officer. Count one, I'm going to set your bond at 102, 1,000. Count three, 500. And count four on the warrant, that bond is 500. Don't go back to Walmart.
Judge, I'll invoke his right to remain silent on BOP.
Yes, sir. What can I do for you?
Well, one of those counts I already did time for is probation. I got probation for it.
Okay.
One of those cases never been cleared up in the computer.
All right. Thank you. Thank you. Missing Caleb Montgomery.
North Broward. Hold on. Get in there.
All right. Caleb Montgomery, petty theft, count 1. 2, probation violation for a burglary. So, count 125, 2, no bond. Thank you, sir. Now.
We have 2 PBLs on the docket.
I could have sworn I was just hearing Innocent was saying.
Judge, we
Innocent is declined the public
I
defender.
see Emmanuel Innocent.
This is Mr. Anderson. He has declined the PD, Judge.
I understand. Mr. Innocent, do you have a
Yes, sir.
private attorney?
Yeah, he's supposed to come see me on Sunday.
What is his name?
I'm not sure.
Do you want to reset till Monday
Let me-
so your
let me
attorney
ask
can
you
talk
this.
to the judge?
Let me ask you this. Do you, does your family know the attorney?
Yes.
Okay.
Your Honor can give him the option if he wants a reset for 24 hours, so tomorrow, to contact his family and have them reach out. But
Would you like me to reset this case for tomorrow and call your family and have the attorney come in tomorrow? Do you want me to call your
Yes.
family? Do you have the number for your family?
Yes, I do.
What's the number?
561-860-3326.
Who am I calling?
My mom,
What's her name?
Nelly Innocent. And I got my sister number too.
Hello, Miss Innocent. Hi, this is Judge Hurley. I'm a judge in Broward County. How are you, ma'am? Ma'am?
No,
Well, I'm about to tell you.
She should speak to my sister.
Your son, Emmanuel, is in my courtroom. Your son, Emmanuel, is in the courtroom right now. I'm going to reset the case for tomorrow morning. Would you like to call the attorney and tell the attorney to come to court tomorrow morning? Yes. Why don't you, who is the attorney you're hiring? What is the name of the attorney? Well, I'll reset this matter for 10 a.m. tomorrow morning. All right? Yes, 10 a.m. Okay, you want to write this? Do you want to write this down? Okay, hold on. Hold on. Hold on, man. Sir, what's your sister's number? What's your sister's number, sir?
561-260-9784.
What is her name?
Loera.
Leave a message.
Please leave your message for Loretta.
I'm going to reset this matter for 10 a.m.
And
tomorrow.
I'm gonna wait till the last minute.
All right, you'll be back.
Okay, we have Roberto Gonzalez, Judge. He's also a reset from this morning, and I believe Mr. Afzal has prepared to make any arguments there are.
Go ahead, Mr. We have Roberto Gonzalez. Sir, you have the right to remain silent. If you give up that right today, whatever you say, can will be used against you. So you've been charged with robbery with a firearm on count 1, aggravated battery with a deadly weapon on 2, and you wanted out of county on count 3, which is a burglary of a vehicle out of Henry County. So,
Judge, he's saying he's never been to Henry County.
well, there you go. It's a great defense.
Well, that might be the problem. It's a failure to appear.
Yeah. All right, now, Steve, are you seeking a foreclosed bond and release conditions on count 1 and 2?
Yes, Judge.
Tell me why you believe there's robbery with firearm and aggravated battery.
Your Honor, I think based on the reports that I've provided, along with the sworn statement from the victim, there is proof evident that Mr. Gonzalez committed a robbery with the firearm of the victim. Your Honor, before the officer even spoke to the alleged victim, numerous anonymous witnesses gave specific reports of 3 people in a specific kind of truck, a black truck, committing specific acts, attacking a man, 1 person striking with a gun, then rifling through his pockets and stealing from him. Now, I understand that they were anonymous and that I don't believe names have been listed, but what I think gives it credibility is it's the same exact story that the alleged victim gave. The same exact story that he saw people in a black truck, he was approached by these people, he was robbed, hit in the head with a gun. He gave physical descriptions, one of which matches Mr. Gonzalez. To give credibility to the victim, he admitted when he was shown a photo lineup, he identified Mr. Gonzalez, and he admitted he couldn't identify the second person. He could have easily just said, yeah, it's the guy number 2, but he said, I can't identify him. Additionally, Your Honor, he gave testimony that his pants, they tore apart his pants to rob him. There was physical evidence. I believe the officer took custody of the alleged victim's pants, which appeared to be cut open to rob the alleged victim of his possessions. I just think based on the totality of all the evidence provided to the court, there is proof evident.
Okay. In a response by the defense.
Reserve argument for a future date.
So today the court's going to will find proof evident, presumption great, not only based on the initial affidavit the court got on this case, but there's a incident investigation report which was added to this in a supplement packet, which involves the statement of the alleged victim, and it goes into detail with several reports. So I'm going to order you have no contact directly or indirectly with Jackie Painter. You're going to be held without bond on count 1. Count 2, the court's going to set that bond at $10,000. So count 1, no bond. Count 2, $10,000. Count 3, you want it out of county, no bond. Thank you. Court will find proof of presumption.
Judge, and we're going to invoke his right to remain silent and request a protective order. All right, down you go. Thank you. Judge, we have 1 second look here. It's Gregory Witt. He's been here since when?
I've been here since Monday.
Since Monday on a trespass, $100 bond. He is anxious to resolve if the court is so inclined. And that's WHI.
So I haven't been in trouble in 5 years.
There you go. I've been in trouble in 5 years, Judge.
I was telling her, it's not.
Okay, so. Sir, would you like to resolve your case today, Mr. Wett?
Yes, sir, I would.
Do you understand, sir, that if you plead no contest, the case is over with today? Do you understand that?
Yes, sir, I would.
Huh?
Sir, you're not going to have any.
Yeah, if you go up
You're
and
not
down
going to have your day in court. That case is wrapped up. That's it. Do you understand that?
Yes, sir, I do.
So I'm going to order you do not return. I'll accept you plead no contest. Mr. Witt, do you plead no contest?
Yes, sir, I do.
Okay, I'm going to withhold adjudication. I'm going to order you do not return to the apartment complex at 3380 Northwest 30th Street, Lauderdale Lakes. Do you understand?
Yes, sir, I would not.
Okay, so I'm going to withhold adjudication on you, all right? Thank you.
Yes, sir.
All right, what about case?
All right.
Courtney Case?
We're clear to me. Your Honor.
Thank you.
Hello?
Where's Courtney Case? Mr. Case, I'm going to send this to the division judge.
Okay, what's this about?
Thank you.
Sir, your bond has been posted. You should be released shortly.
Okay. Okay, is that a wrap?
Yeah, actually, could you hold on for 1 second? Hold on, I'm going to transfer this to I'm like, I don't deal with it, so I keep these old and they hand it over. I said, yeah, you are. She's like, hello.
Yeah, it was me.
Was it?
Here, everyone.
Yeah.
That is a wrap. Thank you very much. We'll see everyone back here on Monday.
Are you all right?
We're out.
Well, then you
Hey, I'm not going to stay here.
See ya. We're out.